Appeals for the 15th District of Texas is now in session. God save the state of Texas and this honorable court.
Be seated, please. Thank you for coming, especially those of you that are not getting paid to be here. My name's Scott Brister, Chief Justice, and to my right is Justice Scott Field. To my left, Justice April Ferris. It's a pleasure to be here. We want to give a moment of special thanks to the university, the law school, for having us, letting us use this facility. We're an anomaly. We're the first court of appeals created in Texas in 60-something years. And we're the only one with statewide jurisdiction, which the bottom line means there's nobody that the state government could impose upon, no county they could impose a requirement to give us a courtroom. Legislature has to do it, which they just declined to do last time. So in the meantime, we appreciate the use of the hall here. Thanks especially to Dean Chesney. He's been a great encouragement and a fan of trying this out, and we hope it'll, frankly, we count on graduates from this and other law schools to help us out as interns, law clerks, staff attorneys. So we hope this will lead to more productive connections in the days ahead. So we'll get right to it. First case is 1524-00036, Texas Commission on Environmental Quality and Max Midstream versus San Antonio Bay Estuarine Waterkeeper and others. Who's present for the appellate?
Good morning, Your Honor. Sarah Ferris with the Office of Attorney General. And with me today, we have Assistant Attorney General Katie Hobson, Amanda Cagle, and from TCEQ, we have Contessa Gay.
Great. Welcome. And for appellees?
We have one more appellant.
Oh.
Your Honor, Garrett Steele with McGinnis Lockridge on behalf of Max.
Max Midstream? Okay, great. Thank you. You all splitting time?
Yes, Your Honor.
Okay, I'll count on you to do that, and whenever the time runs out, they'll tell us, and that's it, okay? And for appellees?
Yes, good morning, Your Honors. My name is Erin Gaines. I'm here on behalf of Appalese. I have with me Alon Levine, Karis Adams, and Ethan Siegel.
Great, thank you. Will you all be splitting argument as well, or?
No, I'll be doing that.
All on you, okay, great. All right, you may proceed.
May it please the court. This is an appeal involving a decision by an executive branch state agency utilizing its technical expertise, denying hearing requests and approving Max Midstream's application for a minor air permit. To reach its decision, the commission considered the record before it, including everything submitted by the hearing requesters. The commission determined that the requesters, now appellees, were not entitled to hearing. They had not established themselves or their members as affected persons under the law, with personal justiciable interests likely impacted by the permitted activities. The question before the court today is not whether appellees proved that they were affected persons entitled to a contested case hearing. It's whether the evidence before the commission would prevent reasonable minds from concluding that they were not. The commission engaged in reasoned decision-making. The commission did not fail to consider the relevant factors set out in the Texas Water Code and the commission's rules. The commission did not base its decision or even entertain an irrelevant factor. The commission followed the law and its established procedures in making its determination under the substantial evidence rule and should be affirmed. Today, I will address the standards used by the commission in reaching its decision and how the court will review such decisions. Counsel for Max Midstream will address affected person question with regard to the appellees and their named members. We will rely on briefing for the second and third points on whether the court has jurisdiction to decide the merits of the permit and the court's remand authority, unless the court has questions or they are addressed by appellees. When considering the hearing request, The commission must determine if the requester is an affected person. Texas Water Code, Section 5.115, and the commission's rules of define affected person as one having a personal justiciable interest affected by the application. An interest not common with members of the general public does not qualify.
Counsel, it seems to me that a lot of the rub in the briefing is the difference between this determination TCEQ made and Article 3 standing, the determination that the court would make on standing. Under the substantial evidence rule, it's always confusing because there are a lot of prongs there and a lot of different types of review. It seems to me the commission is taking the position that it is an evidentiary standard where as long as reasonable minds could find there's not an affected person, that's enough. The question I have, and I know there's a long lead up, is what keeps, in a situation like this, where you have a well-funded permit application, they're always going to have an affidavit from an expert that says everything's okay, no one's affected. What keeps the commission from always saying, under substantial evidence standard, you're not an affected person?
Well, first, Your Honor, appellees have admitted that other parties, other people have been found to be affected persons in air permitting. It's in their brief. But additionally, just because a disputed fact is determined doesn't mean that that's the end result. We know that merits are different than an affected person determination. We're at a different stage. For instance, you can provide affidavit to help support your hearing request. If we were in trial or in a hearing on the merits before SOA, that would be a hearsay, right? So we're allowed to provide whatever we can, the requester can provide whatever they can to support their request, and the commission is required to consider everything they provide. But more importantly, it's a matter of, it's a reflection of what forum we're in. If we were in district court and this was a plea of the jurisdiction and the matter was intertwined, it would go to hearing. But the Water Code prohibits the commission from granting a hearing on the merits to someone who is not determined to be an affected person. Ty cannot go to the runner on this. And they have equipped the commission to use their technical expertise to make this determination. They use the information in the application. They use the draft permit and the terms thereof, and they have to, because what we're trying to determine is the likely impact on the requester. They're required to determine the disputed fact. It's not an option.
So usually in Article 3 standing, it's a question of law. It's not, we don't give standing to a jury, decide, do you think these people should be able to sue or not? That's just up to the judge. And that usually means, in your conventional cases, if there's, well, maybe they are, well, maybe they aren't, especially in Texas state court, that's a jury question. Now, we're not going to ask the jury, but we're going to send it to the jury, because after all, if there's some evidence they are, some evidence they aren't, you send it to a contested case, the issue of whether they were an affected person basically goes away, because then you just have the contested case and you decide you're entitled to merits or not. This doesn't feel like that, because it does feel like you're talking about factors and fact findings, and they're saying you can't do that. Why do we get to treat it differently as standing?
Because the determination, how the determination is made, reflects the forum that you're in. We're an executive branch agency that's charged with technical matter expertise. They have to use their expertise to go through all these highly technical considerations, determine if someone could be affected. Yes, it's harder to establish that you're an affected person in a permit case than it is in a citizen suit where there's ongoing violations. Because under the Health and Safety Code, the application is required to include information, all information necessary to make a determination that the health and safety would not be affected and all legal and technical requirements are met. And in fact, if a hearing on the merits had been granted, all the information that the commission had considered here, the preliminary decision, the draft permit, the technical memos, all of those things would constitute by statute a prima facie demonstration that all legal and technical requirements were met. And that's in the Government Code 2003.047I1. We're not saying that the commission applied a prima facie case here. I'm just saying that the evidence the commission relied on is such that it would constitute a prima facie case if we were in a hearing.
But of course, a lot of this is kind of, I hate to say guesswork, because you've hired very expensive experts to testify all this stuff. But the plant hadn't been built yet. Nobody knows exactly what's going to happen. And, I grant you, they've got fancy formulas and stuff, but, those. So why shouldn't some of the burden be on you to say, what's the harm of go ahead and have, maybe that's my question, what's the harm of going ahead and having a contested case if everybody's kind of, we don't think it'll affect the people that are fishing and swimming down on the other parts of the bay, or we do? What's the harm in having a contested case?
Well, Your Honor, unfortunately or unfortunately, that was the legislature's call. The legislature said that only the commission cannot grant a contested case hearing to someone who is not determined to be an affected person. They set out factors that the commission must determine, and they require the commission to develop factors. Those factors are undisputedly reflect the Article 3 principles, but how they're applied reflects the forum that we're in. And here, we're here today with you sitting in review of the commission's decision. Did the commission use the required factors? They did. Did they have evidence that would support their position? They did. Did they act in any other way unreasonably? They did not. And according to the Government Code 2001.174, you would affirm. And we know that that also applies, the full scope of that provision applies applies in the air permitting cases. And Your Honor,
Did we use up all your time?
I have used all my time. Your
All
Honor.
right.
I'm going to let my co-counsel go.
Thank you.
Thank you.
May it please the court. I hope to focus my remarks on the underlying facts that are actually in the record, the substantial evidence, and that's what this court is charged to do, is to determine, is there substantial evidence in the record to support the commission's decision? And there is. As Ms. Ferris pointed out, Texas Water Code 5.115 is a legislative directive to the agency specifically how to consider these hearing requests. And that's all the TCEQ did here.
Could I jump you ahead to one of the particular facts in this case?
Absolutely.
So Fraser concluded here that the impacts on public health and welfare further than 1 mile from the terminal would be indiscernible. But we do have facts here that Diane Wilson is getting closer than 1 mile, right?
That's correct, Your Honor.
Right. And so could you just drill down on why not Diane Wilson?
I would be happy to. When Dr. Frazier conducted her evaluation, she specifically looked at each of the hearing requests that had been submitted. She specifically looked at those claimed interests of Ms. Wilson. I think some of them were within 1,300 feet of the terminal. But,
Right.
but those activities were infrequent enough that Dr. Frazier concluded that impacts on Ms. Wilson would not be discernible. In other words, Dr. Frazier said that in evaluating the impacts, you have to look at the magnitude of the emissions. This is a minor new source review permit. As Dr. Frazier points out in her affidavit, the emissions that would be authorized under this permit are a fraction of the federal and state air quality standards. So based on the magnitude of those emissions, based on the frequency of Ms. Wilson's visits closer to the terminal, within 1 mile, and then based on the duration, which was
she the swimmer or the kayaker? Or?
She's the one that goes kayaking, motorboating, and then she's also doing routine visits to observe the plastic pellets.
So, Your Honor, just to follow up, Dr. Frazier specifically looked at Ms. Wilson's claimed interest. In her professional judgment, the impacts of our air permit would not be discernible on Ms. Wilson.
But I mean, in this case, it certainly seems like it would be very hard to extrapolate. I mean, how do we necessarily know it to get to just being an affected person? I mean, is it really? I mean, is that all it really takes to get out of it? Is just to say, like, well, you know, she is within the range, but, you know, probably not frequent enough. I mean, that seems just a little bit imprecise for being able to, you know, just basically get in the door here.
There could be cases, and there are lots of cases where folks that were within a mile or even
Sure.
a little bit further than a mile were granted a hearing on an air permit. TCEQ, the commissioners evaluate all these cases the same based on the statutory directive. And Justice, there are many cases where folks are granted a contested case hearing.
Sure.
And of course, we're used to trial court hearings, and, you know, if you tried this stuff in a trial court, first it'd take 3 years to get to trial, and then the trial would last forever, and then there'd be long appeals, and blah, 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 blah. How is the administrative contested case different from that?
Well, Chief Justice, the contested case hearing process follows the rules of evidence. It follows the rules of procedure. So it's essentially
But not all our discovery rules and
There-
deposition.
Yeah, absolutely, yes,
Are
sir.
there?
The rules of evidence apply. There are depositions. There's robust discovery.
So do they take 3 years to get to the hearing?
Well, that's a great question. The legislature passed Senate Bill 709 in 2015 and said for some types of permits, including this air permit, once the SOA judge takes jurisdiction, the proposal for decision has to be issued within 180 days. And there's some caveats there. And Chief Justice, back to one of your questions about why not just go through a hearing, when the legislature passed Senate Bill 709 in 2015, their main concern was that these contested case hearings take so long, they're resource intensive, not only on the agency and on the applicant, but it also takes more than a fair level of sophistication for the protestants who qualify for a contested case hearing. And it delays the projects. I think some of your amicus briefs point out that these contested case hearings can delay projects for years or more.
But
So
it is kind of, you know, the number one, it's kind of like, well, to get in the door, one of the factors you've got to consider is the merits. And then once you get in the door, we're going to consider the merits. Seems like kind of you're answering the second question to when you're deciding if they're an affected person.
And Your Honor, that issue about consideration of the merits came up in 2 Third Court of Appeals decisions in I believe they were 2014. They were the 2 Sierra Club cases. And the Third Court of Appeals said that when TCEQ considers these hearing requests, they're allowed to look at the merits of the application. And I think a lot of that goes back to Justice Ferris's question about, you know, how do we know? Well, the agency here is the legislatively designated expert. They deal with these kind of issues all the time, and it was the legislature's way of relieving that burden from the court. And the legislature did codify in Senate Bill 709, in the same legislation I talked about a few minutes ago, that the merits could be considered as the commissioners are evaluating these types of hearing requests.
Final thoughts for a minute or two? Does the red light mean the time's up? Okay.
I do believe my time is up, Your Honor, but.
Well, final thoughts for a minute or two?
My final thoughts would be that, as pointed out in the briefing, this is a very complex decision that the TCEQ commissioners are charged to make by the legislature. They followed exactly the statutes and their own rules in this case in determining that the hearing requesters did not meet the standard. They didn't prove that they have a personal justiciable interest. And Justice Ferris, it gets back to there was evidence in the record, substantial evidence in the record, that the impacts just aren't discernible.
Thank you very much, Mr. Seal. Ms. Smith?
Yes.
I'm sorry, Ms. Gaines.
Oh.
Good morning, Your Honors. And I would like to point out that we have two of the members of the appellee groups here, Ms. Diane Wilson and Mr. Mauricio Blanco. Diane Wilson, as Justice Ferris noted, is a lifelong resident, fourth-generation shrimper. She kayaks regularly. She monitors the water quality. She's very invested in this community. Mauricio Blanco has been a commercial fisherman, oysterman, for over 30 years, and oysters in these bays within 1 to 2 miles of the facility for months out of the year. Now, I'd like to get back to the positions that appellants are taking that you just heard and that are in the briefs. And we can sum them up looking at actually both of the two claims that we've brought here and see that TCEQ is asking this court to take an extreme interpretation of the law, one that would mean that they could block any pathway for community members like Ms. Wilson and Mr. Blanco to seek judicial review of its permitting decisions, and that TCEQ's decision would have to be upheld. As you noted, we are just trying to get in the door here, to have a hearing. That is what these community members wanted, to make sure that this permit is protective of the health and safety and meets all the applicable requirements.
Well,
And
the problem here, though, is that you've got a pretty tough standard, right? Or for how we have to review, and in this case,
are you referring to the APA standard,
Yes.
Your Honor? So we believe that they are misconstruing that standard. Yes, there is one basis out of the APA standard, out of the 6, that is not reasonably supported by substantial evidence. There are 5 other bases, and clearly courts look at them sometimes under the error of law, sometimes under arbitrary and capricious, and it cannot be collapsed into solely a factual analysis. I do not believe the APA standard allows them to misapply the law, but say we can point to one fact in the record that supports us.
So who chooses? I've been years now reviewing APA cases, and the substantial evidence rule to me is still a mystery in many ways. I mean, how do we know which of those prongs applies? Or is it a mixed question of fact and law, and therefore it's a little bit of both? I guess in some ways, our standing decisions and immunity, and just in normal cases, you're always looking at evidence and deciding questions of law. So how do we know which standard really applies here?
I think, Your Honor, there are cases such as the Dyer case out of the Texas Supreme Court where plaintiffs or the groups bringing the claims raise different claims, and they say, look, this was an error of law. This, you have to look at the facts. And so it really it does depend on the case, and depends on the claims that were brought. I think it also depends on a lot of cases under the substantial evidence review did go through a contested case hearing. It might make more sense to look at whether give that deference, look at whether there is any fact in the record that supports the agency's conclusions. When you've gone through that full evidentiary trial, you have findings of fact and conclusions of law. Here we have an order that doesn't give reasons. It says we reviewed all of these things, but it doesn't give any reasons. So then we're looking at the record, and I think it's clear that you cannot support an agency determination if it was based on the wrong legal standard.
Sure. I mean, if you don't consider some of the factors, if you don't, consider one side's affidavits, you guess, though, I guess, what does that mean? If you don't say, oh, gosh, we looked at that and we really thought about it, then you're out, but usually they're not that dumb. They'll say we considered all of them. And, we are just, perhaps they do it here at UT Law School, but we don't. I didn't study anything about ambient air flow or, how many parts per million of NO2 is bad for you, or what the duration and magnitude, and how if the deal is you just got to have an expert, they got to have an expert, you both got an expert, so we do a trial, and then on substantial evidence review, we're supposed to do what? Because we are not experts in that. it's got to be there's got to be some level of deference to the supposed experts.
So I think it's important to come back to that TCEQ has affirmed in this briefing, although I would argue not in how they applied the facts of this case, but in its briefing and to EPA, this is a federally delegated air program, that there is no material difference between TCEQ's standards and for affected person status and the standards that federal courts apply. So I think as you were discussing earlier, courts do this all the time, standing determinations, whether it's in federal court or state court. And the level of burden changes as you go through the process. At this stage of the process is more of a pleading or plead of the jurisdiction standard, where you have to have, we do have a burden. We had to have people, in this case, we have groups, and they have to have members that show that they have personal justiciable interests. Not everyone will be able to do that. Not everyone can say that they have fished in this area for 30 years, or they regularly go out and monitor for water quality. So it's not that anyone can come in and raise any fact about the permit. You have to have a personal justiciable interest. And here we have those personal justiciable interests. We also have expert declarations and reports that challenge the very merits of the permit that they are taking as a foregone conclusion to assume that there are no health and safety or recreational or aesthetic impacts.
You don't disagree with TCEQ that you disagree with that their measurements are accurate. You don't disagree that the standards they apply are well below the federal standards.
We do disagree. We did dispute that, Your Honor. One of the disputed issues, so there's a long list in the record of disputed issues that we raised in comments and expert reports that would have gone to the contested case hearing. And one of them is, do they comply with the federal ambient air quality standards called the NAAQS, for example? And that is because our expert has testimony in the record that these emissions are underestimated. So they're saying they have, different storage tanks, they have
Right.
vapor combustion units, and they're saying it's going to be this level of emissions based on certain estimates and factors. And we say, no, it actually will be 4 times higher than that.
But I'm talking about the standard is, if it's below this, we're going to say it's indiscernible. If it's above this, it's bad for your health. Those standards are not disputed. It's whether they're measuring them right.
It's actually, I would say it's both, that they are presuming for standing purposes, again, that there's no impacts if you meet these permit requirements. And by the way, in a permit review, TCEQ, to issue a draft permit every time has to determine that it will meet these permit requirements and these air quality standards. And that means that in every permit, they can make that determination based on what they're saying they're allowed to do here. They can make that determination, this will meet all permit requirements. And it doesn't matter what a community member says in terms of where they live or where they work. They're going to say if it meets those requirements, no impacts to your health and safety. But we have Dr. Hopkins here, a declaration by Dr. Lauren Hopkins, and she says that even if you are below those ambient air quality standards, that doesn't mean there's no health impacts. She says that nitrogen dioxide emissions from this terminal, based on solely their modeling, so not even presuming that their modeling is underestimated, would increase baseline levels by 50% up to 2 miles away. And then her opinion, she's a public health expert, is that will negatively impact Ms. Wilson, Mr. Blanco, Mr. Miller, and Mr. and Ms. Marsh, who live in Point Comfort, where they live. And those are because they have activities or they live within 2 miles of the facility. But under TCEQ's interpretation, they could resolve all of those disputed facts, and they have admitted that they did here. I think their position might change slightly through the briefing of whether they are allowed to weigh and resolve disputed issues of fact only that go to standing or that go to the merits, but clearly they resolved disputed issues that go to the merits that we had raised in our comments here. And then they could deny anyone a contested case hearing on the basis there would be no likely impacts, in their view, because they have already determined that the permit meets all these requirements. And then, on the second claim, so we also brought a claim challenging the issuance of the permit itself. They say, well, actually, you're not allowed to be in this court because you didn't go through a contested case hearing. You didn't exhaust your administrative remedies. So that blocks all pathways to judicial review of this permit.
Do we ever, the public hearing's entirely on a written record? Don't call witnesses and swear them, or do you?
The contested case hearing?
No, the public hearing before about whether they're going to have a contested case hearing.
The public hearing that the commissioners hold?
Yes.
I'm asking because there are certain different terms of art in the TCEQ process.
Whatever you call it when we're looking at the.
The commissioners' meeting.
And that's all on a written record.
That is, the three commissioners have a public meeting, and it is recorded.
Okay, so people come to the mic and have how many minutes to say what they want to say?
Actually, on affected person determinations, it's all on the record. You can
That's all
show up.
That's all I was asking.
Yes, you can show up, but they don't. They can ask you questions if they'd like to, but you don't have an opportunity.
So a hearing, you put people on the stand?
So a hearing, you put witnesses on the stand, you do pre-filed testimony that's subject to the rules of discovery. And there is actually a third option, which we haven't discussed, which is that TCEQ can determine itself, as it did here, whether a person is an affected person and refer it to SOA. Or they can say, we're going to refer that affected person determination to SOA to determine if you are an affected person. So they can actually hold a hearing just on that determination where you put on witnesses and you do cross-examination.
Do you agree that there is deference to TCEQ's determination here at all?
Not on the legal standards. I think that's a question of law. If there is a factual dispute and they are allowed to weigh facts, there is that basis under the substantial evidence standard. But
Right,
I
so
don't.
if they're choosing between two experts on whether there are going to be discernible health effects, that's within their discretion.
Not at the standing phase. Not if there's disputed. Not if there's disputed facts over that in the record. And if you look at the standard under TCEQ's rules, 55.201, 30 Texas Administrative Code 55.201, it's tab 2 from Appellant's Exhibit. It lists what you have to, so there's the factors, but then it lists what you have to do as part of this process. Under subpart D, it says a hearing request must substantially comply with the following. Give your name, address, lists all those things under 1. Under 2, it says identify the person's personal justiciable interest affected by the application, including a brief but specific written statement explaining in plain language the requester's location and distance relative to the proposed facility or activity, and how and why the requester believes he or she will be adversely affected by the proposed facility or activity in a manner not common to members of the general public. That is your instructions of what you're supposed to submit. We submitted numerous comments that have more than I would argue is a brief but specific written statement. We identified members, and then in response to Max Midstream's expert report, we submitted 2 expert reports. That goes well beyond what these rules, I would argue, contemplate you need to show at this standing phase. And on the point about the rules allowing determination of the merits, TCEQ, after the legislature added those rules, and those are discretionary factors, so there's mandatory factors and discretionary ones, they explained to EPA to try to show how their program continues to comply with Article 3 and being being equivalent to Article 3, says TCEQ does not consider discretionary factors in 30 Texas Administrative Code 55.203D that may not be consistent with the determination of Article 3 standing, such as the merits of the underlying permit application in evaluating whether a hearing requester is an affected person. So TCEQ's Attorney General is saying to EPA in its statement of legal authority, and that was in September 2020, that's Max Midstream's Appendix U, to the briefing, that it will not actually consider any discretionary factors that would be in conflict with a determination under Article 3. To go to the facts here, like I said, we submitted 2 expert reports on affected person standing. Dr. Hopkins, who I've said gave her opinion about nitrogen dioxide increases, the respiratory impacts that could have. One of our standing members, Curtis Miller, also a lifelong resident of the area and runs his family seafood business. He has asthma, and he fishes within 2 miles of the facility.
Remind me, this isn't a refinery. This is a pipeline and storage facility, right?
Storage and export terminal.
And is the pollution air pollution we're concerned about is gases escaping during transfer or what?
It's from different parts of the facility, the storage tanks, there's vapor combustion units, the loading processes, so it's from those different processes.
And they make, reminded us several times that there's basically nobody living within a mile of the plant.
There's no one living within a mile of the
It's
plant.
businesses. It's, like we have lots of places we put all the refineries in one place. And, if you live in Pasadena, you just know that when you buy your house in Pasadena. But otherwise, there's other places. And we've got to put these things somewhere or the Europeans will starve in the cold this winter. We've got to get stuff, and we're the biggest producer or the biggest exporter. So what, how far is too far? I understand, yes, you don't want people swimming around where these giant tankers are, pulling up to the dock, but, that's not what we got here. We're along the coast a bit, not that far. You can see, I suppose you can see all this from where they shrimp and where they have the seafood restaurant and all that.
I would argue, Your Honor, that it's not, that the question is not about should this be located there or not. It's about, are these community members, fishermen, lifelong residents affected, and should they get a contested case hearing to ensure that this terminal meets all of these public health and safety requirements? So that
And
they
Diane
can-
Wilson's the only one going within 1 mile, right? Is that?
That's correct.
Okay.
And then we have John and Janet Marsh, who live in Point Comfort, which is the closest town. This is on a peninsula, but it's the closest town. They live about 1.7 miles away. And they already live next to a large petrochemical complex and already suffer from some of the air quality and know what it's like. And they want to make sure that if there's another facility, that it meets all of those requirements. We're really talking about these community members. Do they have a stake in this? And do they get this hearing to have their day in court? Or are they blocked at every pathway because TCEQ has already determined a foregone conclusion in their minds that this permit meets all applicable requirements and therefore no one is affected?
As you can probably tell, I'm still struggling with the standard of review a little bit. Let me ask you the converse question I asked Ms. Ferris, which is, y'all come in with your application and you fill out the form and you end up getting experts in response to their expert. How do you know when you've met your burden? Is it the case that as long as the applicant or contester or whatever the term is has evidence, they're always an affected person? It takes it out of the TCEQ's line of expertise? How do you know? How does TCEQ know?
Well, you have to meet the standard, first of all, in the water code. So you have to show that you have personal justiciable interests. And like I said before, not anyone can just come in and say that. It's been pointed out in this case that there were thousands of form letters that people submitted. We're not arguing over those, people and those form letters. We're arguing over the people who live there and work there and regularly visit around this terminal. So I would say, Your Honor, it's if you've raised personal justiciable interests that go to the factors that they're required to consider, use of the natural resource, your health and safety and use of property, and if you have raised disputed issues about how you will be impacted and about the merits of the permit, then I believe that that's enough for the pleading or plead of the jurisdiction phase. That's how it would get decided at those determinations. And so you're reviewing TCEQ's decision to say, did they improperly weigh disputed issues? Which is different than after a contested case hearing and they're determining, did it meet the applicable air quality requirements?
But it's still a substantial evidence review in that situation? Because you understand that's a very deferential standard if you are looking at the resolution of facts.
Right, and we're not talking about whether there was a fact in the record. We're actually saying they applied the wrong legal standard, or they applied an improper distance standard, or they ignored recreational aesthetic impacts, which they, under their factors, are required to do.
Okay.
I see that I am over.
Well, last thoughts, 1 minute or less?
Okay, thank you, Your Honor. So I think it's clear from the record that the only way that TCEQ could have denied hearing requests of these community members is if they improperly weighed and resolved these disputed issues that go to the merits of the permit against hearing requesters. And the district court properly remanded this air permit back to TCEQ for a contested case hearing because appellees like Diane Wilson, Mauricio Blanco, who are here today, lifelong residents and fishermen in this community, clearly demonstrated that they have standing and met their burden of raising those disputed facts. They deserve their day in court to ensure that this terminal is protective of their health, safety, and livelihoods, and we urge you to affirm the district court's judgment. Thank you.
Thank you, Ms. Gaines. Rebuttal?
Thank you. The appellees had an opportunity to be heard, a meaningful opportunity to be heard. It is not limited to contested case hearing. The Health and Safety Code provides for public meetings and public comment, and they participated in both of those activities. The opportunity to be heard through a contested case hearing is limited to affected persons. The City of Aledo case and the Sierra Club versus TCEQ case tell us what the commission must do when considering the affected person question. They say the burden is on the requester to establish that they are affected persons entitled to contested case hearing. There's no right to an evidentiary hearing on an affected person question, provided that the person has had the opportunity to express their dissatisfaction with the proposed permit and that TCEQ does not refuse to consider the evidence offered in support of that dissatisfaction.
But how do we know if they've met their burden? That's the rub. I keep hearing you say it's their burden. But how do we know if they've met their burden?
Your Honor, that is the commission's determination. It's your determination to determine whether the commission acted unreasonably in reaching that decision.
In other words, if you have some evidence that you could base your conclusion on, we defer to the commission, which is the same standard we would use if there was a contested case hearing. That doesn't make sense to me.
But that's what the cases say.
Right, and I know the cases said up until 10 years ago that we deferred to the commission on questions of statutory construction. We no longer do. So what do we do with that?
Well, it's not limited to evidence. We know that the substantial evidence rule also includes arbitrary and capricious and error of law, as Ms. Gaines said. But on arbitrary and capricious, for instance, it does not divorce itself from substantial evidence. Only in rare cases where substantial evidence is present will there be an arbitrary or capricious act, and that's where we look at. Did the commission apply the required factors? Did they apply an irrelevant factor? They expressly refuted any notion that there was some kind of unwritten rule. They applied their factors. They said so on the first page of their order. Their order explained the basis for the decision. They said they considered all of the pleadings. And they also adopted their response to comments, which addressed the public comments, those substantive concerns, and also addressed affected person question. They had their opportunity to participate and express their dissatisfaction, and that's all that's required. The order does not have to have findings of fact and conclusions of law. That's a separate subchapter of the APA dealing with contested cases. But they did explain what the basis of their order is. Also, the Collins case says that they don't have to have findings and conclusions on the affected person question. The exhaustion of remedies, they said, well, we can't get to the courthouse because we don't have contested case. When that administrative remedy is available, yes, you have to exhaust that. We know that from the Sierra Club and Public Citizen case, I believe. I do cite it in my brief. But not all cases, not all permitting requires contested cases. They have other remedies that must be exhausted. In this case, for instance, one of the issues that the commission considered was the appellees alleged that particulate, CO2, would affect the water. But CO2 is not a permitted emission under this permit. It requires another type of approval, like with the greenhouse gas approval. That type of approval does not require a contested case hearing, and they would be able to seek judicial review of that approval. That approval is not before the court today because it's not part of this permit. The discretionary factors, they complain about the use of the discretionary factors. The discretionary factors are in the law. They're allowed to use them. And in fact, they authorize the appellees to provide those expert affidavits that they did provide that the commission considered. The commission did what they were supposed to do. They followed the procedure that they, as an administrative body, were charged to follow. They applied the factors that they were charged to apply, and they considered the disputed evidence using their technical expertise as the legislature designed, and their order should be affirmed.
Thank you very much, Ms. Ferris.
Thank you.
We'll take the case under advisement. We'll take a 5-minute break. Those of you that may be students, I know you have better things to do probably, but we do want to make ourselves available. We should be finished with the other argument around 10:30, 10:40, and we'll be happy to hang around for 5 or 10 minutes. You have questions about internships and law clerking and being a judge. You never know. You know, I was a law clerk, I don't want to say 45 years ago, and the great thing about being a law clerk is the court, you're there for 6 months, and these people seem so smart and so interesting and so confusing. And then the second 6 months, I was thinking, like all intern law clerks do, this is not that hard. I could do this. And sure enough, now we get to do it. So if you have questions, please back if you need to go. But if you want to come back and ask a few questions, 10:30, 10:45, would love to speak with you. So we'll stand adjourned for 5 minutes.
All rise.